Okay, today we're going to look at judgment and sentencing. We're going to look at judgment and sentencing. So, judgment is the decision of the courts, which has decided the rights of the parties, as was said in the case of Obi against Obi. Since this coursework, we have been dealing with so many criminal issues from the point of investigation to arrest to searches, to drafting the charges, and then we brought the person to court, by way of arraignment, and then we examined the person's witnesses, and then the prosecution presented his case, and the defendant also presented his case. You understand? And then the parties adopted their final address. Prosecution replied, or he did not reply, depending. You understand? And then now, finally, today is fixed for judgment. You understand? So judgment marks the end of a criminal trial. Judgment marks the end of a criminal trial. You understand? So judgment is that final finding of the court. You understand? After it has weighed the evidence of the parties. But now it's relevant to note that the judge in writing his judgment, the judge in writing his judgment must comply with certain standards. Every judgment have basic legal characteristics or basic legal content. And if a judgment does not contain any of those things which it is supposed to contain, then such a judgment may be rendered invalid. You understand? Such a judgment may be rendered invalid. So look at the contents or the characteristics of a valid judgment. One of them is that such a judgment must be in writing. You understand? Now, this is constitutional. If you look at section 294 sub 1 of the Constitution, you understand, you notice that every judge in Nigeria must have to write his judgment. You understand? He must write his judgment, deliver it in open court, within 90 days from the close of evidence or the final address. And then within 7 days, give a certified true copies of the said judgment to the parties. You understand? So one of the conditions you can find there is that every judgment must be in writing. You understand? Every judgment must be in writing. The judge must write his judgment. He cannot deliver judgment orally. You understand? He must write his judgment. He must write his judgment. He cannot deliver his judgment orally. If he delivers his judgment orally, it is invalid. You understand? Such a judgment is invalid. Una Kalamba against COP. And then it's relevant to know that oral judgment has variants. Oral judgment has species. You understand? There are different types of oral judgments. You understand? There are some judgments that look as if they were written, but in the eyes of the law, they are still oral judgments. You understand? For instance, a judgment that was delivered orally in court, but then was later reduced to writing in the chambers, remains an oral judgment. You understand? So if at the end of the case and then on the day which is the day of judgment, the court orally delivers his judgment by saying, this is my judgment. I hold the defendant guilty. I do this, I do that. The judge is just saying it from his mouth. You understand? And then later on, he goes inside his chambers and then write down the judgment. You understand? He writes down the judgment. In that case, such a judgment remains an oral judgment. It is invalid. And then also, reading the judgment from notes made during trial is oral judgment. You understand? When you go for your externship, you notice that while a defendant or while a witness is talking or while the prosecution is making any statement, you will notice that as the parties to the criminal trial are talking or arguing or saying anything or addressing the court is usually writing. You understand? The court is usually writing down the whole proceedings. You understand? That in his writing is not the judgment. You understand? And then he cannot read his judgment from that in. And the totality of everything he writes there is what he's supposed to go back later, sit down, and draft a standard formal judgment. So if he writes from that his notes that he was taking down what the parties were saying and the issues and all that, that is not, that judgment is not in writing. Such a judgment remains oral. And then reading the judgment from notes prepared by another person, e.g., maybe the son of the judge or the daughter, also constitute an oral judgment. You understand? So maybe the son is in court or the daughter is in court, or maybe after each proceeding, the judge goes back and maybe gives the son or daughter assignment, whatever, to be writing down, certain things for him. So, such is still an oral judgment. The judge must sit down on his own and draft a formal, detailed judgment. You understand? So another person will not do that for him. And then a judgment dictated in court to a stenographer or typist is also oral judgment. You understand? So if a judge, for instance, maybe he wants to deliver his judgment, and then he has not written it. You understand? He has not written it, and he wants to deliver his judgment, and then he's saying it orally, and then the typist is typing it out, putting it in a written form. Such a judgment remains oral. The essence of this principle is that every judge must go back. You understand? He must sit down, consider all the issues, all the arguments, all the evidence adduced, and create forth a formal, detailed judgment. You understand? That is going to cover everything that ought to be covered, and then he will not come to court and deliver it in public. You understand? So whenever he does any of these things up, reading a judgment from a stenographer, from the son, whatever, is an oral judgment and it is invalid. But however, it's relevant to note that there is an exception under the ACJA, and that exception under the ACJA applies mainly in magistrate courts. You understand? Mainly in magistrate court. So they say, however, magistrate court under the ACJA may deliver oral judgment provided the decision or finding and reason thereof is briefly recorded prior in the book. You understand? So it is possible that a magistrate may deliver an oral judgment, but this is applicable only under the ACJA. So a magistrate can deliver an oral judgment, but before he delivers that oral judgment, he must have putting down something in writing. Although whatever he's putting down in writing is not a detailed judgment. You understand? It's not detailed. Maybe he can just putting down these are the issues, these are the evidence adduced, these are the arguments, and then from there he can just deliver an oral judgment. You understand? Whatever he wrote down, he wrote it down briefly, and such cannot be taken to be a formal, detailed judgment. You understand? But because the ACJA permits that, and then he must have taken down those issues, arguments, and so on, just briefly, you understand, in his note briefly, then he can deliver an oral judgment. You can also see the case of Napoleon Osayende against COP. So now we can ask ourselves when to write and deliver judgments. The law is that a judge may write his judgment at the close of evidence, but he must wait until after the final address to deliver same. When we talk about close of evidence, we mean that time where, you can no longer tender any documents, you can no longer call any witness. Once the prosecution has finished with his case, he will usually say, my lord, that is all for the prosecution. And then once the defendant also finish his case, he will say, my lord, that is all for the defense. In that case, there's what we call close of evidence. And then the next thing parties have to do is to file and adopt their final address. You understand? So a judge may write his judgment at the close of evidence. So immediately the parties close their evidence, the judge can now, if he wants, he can cool down based on the evidence adduced and everything, even before the final address. You understand? He can write down his judgment, but he will not deliver that judgment. You understand? He will not deliver that judgment until after the final address. You understand? It is after the final address, that the judge can then deliver the judgment. And then now you ask yourself, can judgment be delivered in the absence of the judge who heard the case? You understand? Can a judgment be delivered in the absence of the judge who heard the case? Now the law is that a written and signed judgment by a judge may be delivered by another if the trial judge is ill or unavoidably absent. You understand? So if, for instance, a particular judge who heard the case, I think this principle should be more applicable in a trial court. You understand? In trial, because at the appellate level, at the Court of Appeal and at the Supreme Court, it's totally a different thing. You understand? It's totally a different thing. But now at the trial court, they are saying here now that a judgment that has been written and signed, by a particular trial judge, but then that trial judge becomes ill, he becomes sick or becomes absent, for reasons that are unavoidable. And in that case, then another judge can deliver that judgment in his absence. But that judge that will have to deliver the judgment must have to sign that judgment again. You understand? That is one of the basic preconditions. You will see that later. He must have to, sign that judgment again before he delivers it on behalf of the absent judge. And then another characteristics of a valid judgment is that every judgment must state points for determination. When we talk about points for determination, we are talking about, for instance, from the judgment. When you read the judgment, you should know whether or not the defendant committed the offense. You should know the ingredients of the offense. You should know the evidence adduced by the parties. And then you should also know the fact of the case. You understand? You should also know the fact of the case. You should also know the fact of the case. And then every judgment must provide decision thereon. Understand? Every judgment must contain a decision. Understand? A decision is a verdict. A decision is a verdict. That is, you have found the person either guilty or not guilty. You understand? Based on the points that was determined. You understand? So the decision flows from the points determined. The decision you are going to give flows from the fact of the case. It flows from the evidence adduced. It flows from the ingredients of that offense. You understand? So when you look at those points and then you determine them as a judge, then you now have to give your decision. And then every judgment must include reason for the decision. You understand? Every judgment must include reason for the decision. This is what we call ratio decidendi. You understand? Every judgment must contain a reason. You understand? Whether it is court martial, whether it is whatever court at all, whatever court at all must have a reason for its decision. You understand? It must be given by all courts, whether it is a magistrate court, whether it is a court martial, whether it is even an area court, any court at all, even courts of the lowest rank in Nigeria, they must give reason for that decision. You understand? Any judgment without a reason, if a judgment is given and a reason is not provided for such a judgment is a nullity and may be quashed by the court on appeal. And then it is also relevant to note that the court cannot defer giving reason for that judgment. For instance, a judgment cannot be given today, and then the court will say, okay, later on we'll say the reason why we gave this judgment. You understand? The judge have to give his judgment and also state his reason at that particular time. And then it's relevant to know that if a judgment is correct, such a judgment cannot be set aside because it was given based on a wrong reason or procedure. You understand? If a judgment is correct, you understand? If, for instance, the judgment of a court is correct in the sense that it did justice to the case, but the reason the court is giving is improper. You understand? The court on appeal will not set aside such a judgment. The court is concerned with the outcome of the case and not necessarily the reason adduced. Understand? So if the intended outcome was to do justice and justice was done, then whatever reason the judge was giving becomes immaterial. And then there's something called perverse judgment. What does it mean that a judgment is perverse? You understand? A judgment is perverse if the judgment is inconsistent with the evidence on record. You understand? So imagine if the evidence on record is suggesting that this person is not guilty, and then the judge goes ahead to hold him guilty. You understand? Such a judgment is perverse. And then a judgment can also be perverse because principles of law were wrongly stated. You understand? Where principles of law were wrongly stated or wrongly applied to facts in the judgment, such a judgment is perverse. You understand? Maybe, for instance, the principles of law says a person, for instance, must do this before he can be considered innocent. And then from the fact of the case, the person did not do that, so he shouldn't ordinarily be innocent, but the judge declared him innocent. Such a judgment have the principles of law wrongly applied. You understand? So such a judgment will be considered perverse. And then a judgment must be dated, signed, or sealed. You understand? A judgment must be dated, signed, or sealed. Understand? So every judge must date his judgment, must sign it or seal the judgment at the time of pronouncement. At the time of pronouncing the judgment, the judge is supposed to sign it, put down his signature, and then date it. That this judgment was delivered on the dash day of dash 2025. You understand? If the judge fails to do so, that judgment may be considered a nullity. You understand? But however, it's relevant to note that a judgment written and signed by one judge may be delivered by another judge due to unavoidable absence or illness, and then that other judge will then date it and sign again. You understand? So where, for instance, a judgment has already been written and signed by one judge, but he has not delivered it. You understand? If that trial judge is absent or is sick, another judge can then deliver that judgment and then date it and sign it again. He can date it and sign it again. So it's possible for a judgment to have double signature, and such a judgment will still be valid. And then also where a judgment is not signed, but immediately followed by ancillary orders made by the court with a signature thereafter, the judgment is valid and compliant with the law or hierarchy against the state. You understand? So maybe in a judgment, oftentimes the judgment will contain what they call ancillary orders, that is, orders that are necessary for the enforcement of the judgment. You understand? So if it, because once you're done, once for instance, I think the proper place to sign a judgment is at the foot. You understand? So immediately you have written on your judgment, then probably you sign it at the foot. You understand? So what this principle is saying, that maybe after it gets to the end of the judgment, you didn't see any signature, but then the judge included ancillary orders, that is, orders that are necessary, directives that are necessary for the enforcement of the judgment. And then thereafter, after those orders or directive, a signature was now contained there. That judgment is still valid. You understand? It's just a matter of formality. And then it is also relevant to note that while an unsigned judgment is worthless, you understand, an undated judgment may still be considered valid. You understand? It may still be considered valid, provided there are evidence to show the actual date in which the judgment was delivered. You understand? So signing of a judgment has more weight than the dating of the judgment. Although dating is very important. You understand? Although dating is very important because dating your judgment helps in calculating the 90 days requirement to deliver the judgment, and also in calculating the time of appeal. Understand? And then it's relevant to know that the relevant date here, like when they say within 90 days, the relevant date here is the date in which that judgment was delivered, and not the actual date in which that particular judgment was dated. You understand? So you might ask yourself, why should judgment be delivered within 90 days from the date of final address or close of evidence? Now, this is very important. You understand? This is very important. It's very, very important. It's very, very important, as we shall see later. You understand? Or maybe briefly, I can just say it's important because I think our lecturer then explained that factor. He said it's very, very important for judgment to be delivered within 90 days. You understand? Within 90 days, so that the judge does not lose impression of the witness, the demeanor, the evidence that was adduced, and all that. So he has to deliver his judgment within 90 days. And then now we might not ask ourselves, how did we know that the judge delivered his judgment within 90 days? You understand? From the date of final address. How do we know? It's through this dating. You understand? So that is the importance of dating. Understand? When you date when a judgment is delivered today, and then the judge dated that judgment today, you understand? So if you count back, you know that the judgment was delivered within 90 days. You understand? So dating is very, very important. And then dating will also know. Dating will also help us to know. Dating will also help us to know. Dating will also help us to know the time of calculating appeals. In criminal litigation, they don't do like civil. In civil, they will say final judgment within 3 months, interlocutory within 14 days. But in criminal litigation, all appeals, are to be made, whether final, interlocutory, within 90 days. You understand? So it is by dating your judgment. When a judgment is dated, it is delivered on the 1st of January 2025. You understand? So anybody that wants to appeal, whether the prosecution or the defendant, we know that his time has started counting. You get? So dating a judgment is important. Dating a judgment is important. It goes to signify compliance with the 90-day rule, and then it also goes to show or signify to the parties when necessary that they have to appeal. So how do you prove signature and date of the judge on the judgment? It is proved through the manuscript of the judgment, not the typed version. Understand? So if you want to show, if there are dispute or doubt that a particular judgment was not signed by the judge and dated by him, what to be shown on appeal to prove that it was really signed and dated is a manuscript. You understand? So that particular one that the judge wrote with his hand, and not necessarily the typed version. You understand? So if the one he wrote with his hand is signed and dated by him, then obviously he really signed and dated it. The typed version, they can manufacture or fabricate signatures and dates. And then now, where a judgment is invalid, what kind of orders, what kind of orders can the appellate court do? When we talk about judgment in this sense, like in the sense we have been talking about, we are talking about a trial court, high court, federal high court, NIC, all these are trial courts, magistrates and all that, they are trial courts. for the purpose of criminal proceedings, their trial courts. And then, so now we're seeing what orders can the appellate court make where a judgment is invalid. So where, for instance, the trial court, like state high court or federal high court, gives an invalid judgment, and then one other party has appealed, you understand? What orders can the court of appeal make in respect of that invalid judgment? They can order a retrial, you understand? They can order a retrial. That this judgment is invalid and the case should start afresh, you understand? It's possible. And then they can also order an acquittal, you understand, where a retrial will be unjust to the appellant. So this goes to show the weight, you understand. So it's not just about, law has a lot of technicalities. You get, law has a lot of technicalities, which is why most times judges are adjourned to do more of justice, than technicalities. And then, the laymen on the street, oftentimes they don't understand these principles. That is why sometimes they will say, oh, law is filled with injustice. I know, yes, there are some degree of injustice in law, you understand, and especially political compromising of the judiciary and all that. But there are also a lot of technicalities in law. So you can imagine, maybe a prosecution has argued and then a person has been convicted, and then because the judgment is invalid, you understand, because the judgment is invalid, the court can order a retrial. They will have to start again. The court can also order an acquittal to acquit the convict, to acquit the appellant. You get, so this goes to show the weight or the importance on why a judge, should make sure that he gives a valid judgment. You understand? It goes to show why a judge should make sure at all times that he complies with the law to give a valid judgment. And then what are the circumstances when the court will order a retrial? What are the circumstances when the court will order a retrial? So the court will order a retrial when that order of retrial will not be oppressive on the appellant. You understand? When the order of retrial will not be oppressive on the appellant. Retrial is very stressful. You have tried the person, convicted him or acquitted him, whatever, and then now you're saying they should start afresh again. You understand? So, you look at the expenses and all. So if the court is of the view that such retrial will not be oppressive on the appellant, the court can order a retrial. And then the court will also order a retrial where refusal to make the order of retrial will occasion injustice. You understand? Will occasion injustice. Maybe, okay, imagine a situation whereby the trial court did not give reason for its judgment. It did not give reason for its judgment. When it knows that ordinarily it ought to give reason for its judgment, but then it didn't give reason for its judgment, or the judgment he gave is perverse, you understand? Such a judgment is perverse. In that case, the appellant will be wanting a retrial, you understand? He will want a retrial. When the judgment is perverse, it's inconsistent with the record on appeal, something like that. The appellant will be happy to say, oh, I need a retrial. We should go back for the case to be retried. The judge did not consider this evidence. He did not give reason for his decision. He did not consider the points for determination, all this kind of stuff. Understand? So where it will occasion miscarriage of justice if a retrial is not ordered, that is one of the circumstances that the court will order a retrial. And then we are leaving the error on the judgment. The evidence discloses substantial case against the appellant. So now, where, for instance, the balance of convenience is against the appellant, and the evidence against him is substantial, the court can say, okay, let's order a retrial. And then where the offense for which the appellant was convicted or acquitted are not merely trivial, you understand? Where the offenses are not merely trivial. For instance, if for instance, offenses for which the appellant, for instance, was tried for is merely trivial. Imagine if maybe the offense was merely trivial. The court can just acquit him if the judgment is invalid. Understand? Maybe someone is being tried for traffic offense or whatever, and then judgment they delivered was invalid, and then maybe it was a perverse judgment. The judge can just say, just acquit him. They can just acquit him. But where the case against him is not merely trivial, the court will not ordinarily acquit him. They will rather order for a retrial. Understand? And then what is the time limit for the delivery of judgments? The time limit, I think we have said something like this. Now, the time limit for delivery of judgments is provided under section 294 sub 1. You understand? So every judgment must be delivered in writing within 90 days after the conclusion of evidence and final written address. You understand? with authenticated copies of the said judgment given within 7 days of delivery to the parties to the suit. You understand? So now this time limit is mandatory, it's compulsory. You understand? Every court has to deliver their judgment within 90 days from the close of evidence or final address. You understand? It's compulsory. You can see the case of State against Lawa. But then it's relevant to note, for instance, that further address by the parties postpones the time limit. You understand? It may postpone the time limit. So maybe it's possible that it's possible that the parties they did their final address today, but then later on the court will convene for them to do another final address. In that case now it's going to push the 90 days period forward. You understand? It's going to push the 90 days period forward. And then parties, but then it's also relevant to know that parties can decide to waive their final address. You understand? And if parties waive their final address, then the 90-day period will then begin to count from the close of evidence. You understand? So if the parties on their own agree that they don't want to do final address, if they agree that they don't want to do final address, in that case now the 90 days within which the judge is required to give his final address now begins to count from the close of evidence. Then it's relevant to know that it could be, for instance, that the parties, the court usually does this as a remedial action. For instance, the parties have made and adopted their final address on a particular date, and then the judge wasted time, and the 90 days is over. You understand? If he delivers a judgment, it's going to be an invalid judgment. You understand? The judgment is going to be voidable. So now what is he going to do to save the situation? He can call the parties back. You understand? He can reconvene the parties, and then they will adopt their final address again and address the court again. You understand? On their cases, and then it will help the 90-day period to start again. In which case, the court can now deliver his judgment. And then it might not be asked: are magistrate courts bound by Section 294 of the CFRN? Are they bound by Section 294 sub 1? That is delivering their judgment within 90 days. Are they bound? This question is very, very important, because if you look at Section 60, of the Magistrate Court Law of Lagos State, it says that judgment should be delivered within 21 working days. So it's more like a departure from the provisions of the Constitution. It's more like a departure from the provisions of the Constitution. But however, it's relevant to note that the magistrate courts are not operating outside of the Constitution. They are in Nigeria. You understand? They are in Nigeria. You understand? So even if the magistrate courts are not, even if they are not directly created by the Constitution, you understand? Like the magistrate court is not a superior court. Even if it's not directly created by the Constitution, you understand? It is relevant to note that the magistrate courts can be said to be created under the Constitution. You understand? Because, for instance, the Constitution grants the National Assembly and the State House of Assembly to enact laws creating any additional court which they feel is proper. And it's pursuant to that power given in the Constitution that magistrate courts and some other courts were created. You understand? So magistrate courts are bound by the Constitution. They don't operate outside the Constitution. So they have to give their judgment within 90 days. You understand? They have to give their judgment within 90 days. And then now we ask ourselves, what is the effect of not complying with the time limit in Section 294 sub 1 of the Constitution? What is the effect if a judge does not deliver his judgment within 90 days from the close of evidence or final address? What is the effect? Now, the effect is that judgment is not void. You understand? The judgment is not void. The judgment is not a nullity. You understand? If a judgment is given 93 days after, 120 days after, the judgment does not become automatically void because it was given outside of the 90 days period. You understand? Such a judgment is only voidable. You understand? Is voidable. Is only voidable. You understand? At the instance of any party affected. And then on appeal, if one of the party then appeals, you understand? If, for instance, maybe the defendant or the prosecution appeals against the judgment because it was given 140 days after, it was given outside the 90-day period, the court on appeal will only consider such a judgment to be a nullity if delivering that judgment outside of the 90 days period caused miscarriage of justice against any of the parties. You understand? So the fact that a judge delivered his judgment, beyond 90 days does not automatically make that judgment to be a nullity. You understand? It is that judgment is just voidable. You understand? So it's possible that when the judgment was delivered, the defendant who was affected, who was probably affected by the judgment, just stayed mute. He didn't want to appeal. Then it's okay. You understand? Because the judgment once given at that time is voidable at the instance of any party. But if he decides to appeal, the Court of Appeal will only consider that judgment to be a nullity, to be void, to be totally invalid if there was miscarriage of justice because of that delivery of the judgment outside of the 90 days period. So, for example, I think the classical case of Apple and others against Igoriogo and others, where judgment was delivered 2 years and 9 months after close of evidence, you understand? And the court held that no, that this judgment is totally invalid. The court on appeal, the court on appeal was like, this judgment is totally invalid. It occasioned miscarriage of justice. 2 years and 9 months is too substantial. It's too substantial. It's too substantial. But it's relevant to know that the burden of proof, the burden of proof is on the appellant. That person who is alleging that the judgment occasioned miscarriage of justice. The burden of proof is on him to show how that the judgment occasioned the miscarriage of justice. You understand? But it's relevant to know that in calculating that 90 days period, in calculating the 90 days time limit, the days of where there are all these public holidays and vacations. Sometimes judges go on vacation, public holidays and all that. You don't include those days in counting the 90 days period. You don't include those days in counting the 90 days period. And then where a judge, for instance, delivers judgment outside of the 90 days period or beyond the 90 days period, ordinarily the Court of Appeal, the Court of Appeal will usually forward a report, against that trial judge to the NJC for proper action. So that is one of the consequences on the judge when he delivers a judgment beyond 90-day period. The Court of Appeal will usually forward the name of that judge to the NJC for proper disciplinary action. So now we might ask ourselves, what is the reason behind the 90-day rule? I've said something like this before. What is the reason? Why must a judge deliver his judgment within 90 days? According to Leonardo Go, Esquire, lecturer at the Lagos campus, he said a judge is a human being. You understand? He usually observes the demeanor of witnesses. So it is important that he does not deliver his judgment over a long period of time. You understand? Because he may actually lose touch of impressions and personal knowledge of the case. You understand? Oftentimes the demeanor of witnesses, the way they spoke, the way they address the court, these are factors that the court considers. These are factors that the court considers. These are factors that the court considers in every case or trial. So imagine when you are delivering a case 2 years and 9 months after the parties appeared before you. How are you still remembering? Are you even sure you remember the facts, apart from the fact that you read it the night before you delivered the judgment? You must have lost touch of the witnesses who, some of the witnesses must have even died, and you don't even know. So you have to deliver your judgment within that 90 days to ensure that everything is proper. So now we go to mode of delivery of judgment in the trial court. The mode. This is more, when we talk about mode, this is more of a constitution of the court. This is more constitution of the court. Constitution of the court in delivering judgments. Now, in a trial court, like the state high court, in the trial court, you understand? In the trial court, just like state high court, the law is that the same judge that presided over a case, the law is that the same judge that presided over a case, you understand? That same judge that presided over a case, should preside over that case from the beginning of the case till the judgment being delivered in that case, you understand? So if the judge along the line, if for instance you are being tried in the High Court of Lagos State 1, and you were assigned to maybe Justice Adewumi or whatever, you understand? Now Justice Adewumi should handle your case from the beginning of your case up to the date in which is to deliver his judgment. If Justice Adewumi dies, is replaced, is removed, retires, is elevated to another court or whatsoever, such a judgment, such a sorry, not such trial, you understand, such trial, any extent you have gone in that trial, even if it was at the point of final address, you know, everything now becomes everything now becomes automatically abandoned, and then the trial must start de novo, that is afresh, before a new judge. You understand? The trial must start de novo before a new judge. It must start de novo before a new judge. Every evidence adduced, witnesses called, all those things now will become abandoned. And see, will go against it. But then it's relevant to note, however, that a written and signed judgment can be delivered and dated by another judge if the original judge is unavoidably absent or sick. You understand? So in this case now, if a judgment has already been written and signed, such a judgment has already been, although it has not been delivered, you understand? But such a judgment has already been written and signed. You understand? So in this case now, there's no need to start the case de novo. Another judge can just come and deliver the judgment, but he must then date it and sign it again. You understand? And this is usually the case where the trial judge is sick or is unavoidably absent. And then it's relevant to note that there was this exception as well. It operated as an exception, although the exception is no longer applicable. You understand? Because the court has held that such an exception should no longer be applicable. But there was this exception under the ACJA, where, for instance, a judge is handling a case, maybe Justice Adewumi is handling a case at the Lagos State High Court. And then while handling that case, he has handled that case to a substantial level. You understand? He has handled that case to a substantial level. It's not just the beginning part of the case. He has handled it to almost the judgment part. And then Justice Adewumi was now elevated to be a justice of the Court of Appeal, for instance. Now, under the ACJA before, the ACJA permitted that Justice Adewumi can go back, even if he has been elevated to the Court of Appeal, he can go back and then finish up that his case that he partly held. You understand? So the case must have been partly held. That was the condition. It must have been partly held. You understand? So Justice Adewumi can go back and finish up that his case instead of the case starting afresh de novo. That was the position of the law under Section 396 of 7 of the ACJA. But this statutory provision now has been overridden. You understand? It has been overridden by case law. You understand? For instance, if you see the case of Udogu against Eparoye and the case of EFCC against Ojizokalo, the court has held that practice is unconstitutional, because by virtue of the fact that the judge has been elevated to the Court of Appeal and he has taken an oath of office, he has sworn to an oath of office at the Court of Appeal, then he has ceased to be a trial judge. He is now a justice of the Court of Appeal. Therefore, he cannot go back to finish up that case that he partly held. So this is now the position of the law, in case you see something like this in exam. Understand? So now, what is the mode of delivery of judgment at the Court of Appeal and at the Supreme Court, that is in appellate courts? We have looked at that of trial court, that judge who started the case must be the one to end it, and they're subject to a few exceptions. But now, at the Court of Appeal, is it also the same way? Is it the justices that held a case that will also deliver judgment in that case? Is it the law that the justices that held a case, that they must hold that case from the beginning of the case up to the judgment of that case? Do we have anything like trial de novo? Do we have anything like appeal de novo at the Court of Appeal? You understand? So we don't have anything like that. The position of law at the Court of Appeal is totally different. And then if you look at the proviso to Section 294 sub 2 of the Constitution, it provides us with the provision of law as it relates to appellate courts like the Court of Appeal and the Supreme Court. So now, it says that it shall not be necessary for the justices who heard a cause or matter to be present when judgment is to be delivered, and the opinion of a justice may be pronounced or read by any other justice, whether or not he was present at the hearing. So the implication therefore is that one justice of the Court of Appeal suffices to deliver the judgment, even if others are absent. So it's possible that 3 justices heard a case, you understand, and then on the day of judgment, one can just come, one can just come and deliver the judgment. You understand? One can just come and deliver the judgment, and then if for instance one is delivering that judgment, now the two other persons who are absent, their opinions, you understand, the opinions they gave in the judgment may either be read or pronounced. You understand? The opinions they gave in the judgment may either be read or pronounced. And then it's relevant to note that opinions given in a judgment, when for instance a jury like the court of appeal handle the case, they will usually be like, let me say, three. They will usually be at least three. Sometimes they will usually be like three. That's the constitution. They'll be at least three. Not less than three. They'll be that way. You notice that they will give they will, like, for instance, they will have the main judgment delivered by the presiding officer, and then the two other justices might either concur. They will concur, or maybe two persons concurred and one person then dissented. We now call there two. We call it opinion. So those opinion must be in writing. It cannot be stated orally. It must be in writing. And then any justice of the Court of Appeal that is delivering that judgment will have to either read their opinion or pronounce their opinion. You understand? So now we look at the distinction between reading. We now look at the difference between reading a judgment and pronouncing a judgment. You understand? So, like I said before, where for instance at the Court of Appeal, they are duly constituted when they sit with at least not less than three justices, for instance. So we usually have the main justice, the presiding justice in that particular case. He will give his own judgment, and then the other two will give their own judgment. Although the other two, they usually call it opinion. You understand? They usually concur, or maybe one person will concur, then the other person will dissent, making it a 2-against-1. You understand? So now those are opinion. It's also judgment. Is that a concurring or dissenting judgment? Now, if for instance the presiding justice is the one delivering that judgment and it's only him that is there, now the two other justices who also followed him to handle the case, the two judgments they gave or the two opinions they gave, those opinions now may be read or may be pronounced. You understand? Now, if at the time of delivering that judgment, maybe the two justices that followed him to handle that case are no longer at the Court of Appeal. You understand? They are no longer at the Court of Appeal. Maybe because they have been elevated to the Supreme Court, or they have died, or they are no longer serving at the Court of Appeal, or they have retired. In that case, that justice that is delivering the judgment will not read their judgment. Understand? He will not read their judgment. He will just pronounce their judgment. You understand? So he will not read their judgment. He will just pronounce their judgment. But if they are still serving, they have not retired, they have not died, they have not been elevated, they are still serving at the Court of Appeal, but they were not just available that day to follow him and deliver the judgment, their judgments can be read. You understand? So now what's the difference between reading the judgment and pronouncing a judgment? In the case of pronouncing a judgment, maybe after the presiding justice, who is there alone delivering the judgment, maybe when he has read his own substantive judgment, he can just say, Justice Okon Abang concurred, Justice Chika Okafo concurred. That is what we mean by just pronouncing a judgment. But now, if you want to read their judgment, you have to go in detail. You understand? You have to go in detail. You have to read it word for word, clause by clause. Any points he made. Judgments oftentimes they're very detailed. When you're reading a judgment, it's as if some judges, they can be very intelligent. You'll be reading the judgment of a judge. You will see that he's referencing cases, referencing principles from foreign jurisdiction, referencing scenarios, incidents, economic issues that has happened in the world. He's giving you rationales decidendi for his judgment. So if you are reading his judgment, you will make reference to all those things that he gave, all those things he said. Understand? So you must make reference to all those things. So that is what it means to read or to pronounce a judgment. So you read the judgment of a justice when he's still serving, and you pronounce when he's no longer serving for one reason or the other. You might see A.G. Imo against A.G. Rivers. And then a judgment must also be delivered in open court. This is one of the constitutional safeguards we did back then. A person has to be tried in open court, and judgment must also be delivered in open court. So you don't try a person in public and then you go to the chambers and then you deliver your judgment in chambers. Why? is not proper. You understand? It's not proper. And then another principle we have to look at is the fact that a defendant is required to be present when judgment is to be delivered. You understand? A defendant is required to be present when judgment is to be delivered. You understand? In every criminal trial, a defendant must be present when a judgment is delivered. This is very important because defendant has to be present. He has to be present because it is on the day of judgment that they will convict him. It is on the day of judgment that they will convict him. And then sometimes the court might not even adjourn. The court can still, the court can just do everything, convict him that day, sentence him that day as well. You understand? A judge can decide to read his judgment, like deliver his judgment on a certain day, convict the defendant on that day, and sentence him on that day as well. He might not see any need to adjourn. You understand? So a defendant has to be present. You understand? Remember what we did earlier on. Trial in absentia. Trial in absentia is unknown to our law. You understand? It's not a valid form of trial. You can't try a defendant in his absence. Generally, you understand? And then this principle of trial in absentia also, it also applies to judgment. You can't have judgment in absentia. You understand? It's not proper. It's not proper. But then now, you need to look at this scenario. They say, however, where the defendant is absent and after 2 adjournments refuses to appear, the court may proceed in convicting him in absentia. So where, for instance, the defendant was, maybe he was probably granted bail, you understand? And then he has jumped his bail. After 2 adjournments, he refuses to appear on the day of judgment. Now, the court may proceed in convicting him in absentia, but shall not sentence him until he is arrested or he submits to custody. If the court does otherwise, it is a nullity. You understand? So now, there's a distinction between conviction and sentencing. Ordinarily, conviction is the pronouncement of guilt. I hereby find you guilty for the offense of robbery. You understand? Now, that is what we call conviction. So if the defendant is absent, he has jumped bail, and he has refused to appear after 2 adjournments, the proper thing the court is going to do in that case is to convict him in his absence. But the court cannot sentence him until he is present in court, either because he has been arrested and brought to court or he submits himself willingly. Understand? And if you understand the rationale with this principle, you will appreciate it very well. Imagine if, for instance, like, can the court sentence someone when they have not seen the person? Or let me say the court sentenced you to, once a court sentenced you to, let me say, 60 years in prison, it has started counting. You understand? It has started counting. Once the court pronounces a sentence on you, you're hereby being sentenced to that day in prison, it has started counting. So imagine if the person is in Togo, or the person is in Russia enjoying his life. The person has run away from Nigeria and he's enjoying his life in Russia or in the United States where he escaped to, and then you are sentencing him. So has he started counting? That's the question you ask yourself. Has he started counting? So it's very important that the defendant is in court when he's sentenced, or he can be convicted in absentia. And then when we talk about form and style of judgment, you understand? So a judge can actually adopt any style he wants in writing his judgment, you understand? A judge can actually adopt any style he wants in writing his judgments. But he must make sure that those basic requirements, that the judgment is in writing, it has all the necessary contents and characteristics. It has all the necessary content and characteristics. So any style you want to adopt, I was giving you a scenario of some judges, how they usually draft intelligent judgment. They will make reference to economic policies over the world, world trade issues, including foreign decisions of the court in writing their judgments, So any style you want to adopt, you can adopt, but make sure that those characteristics of a valid judgment are contained in that your judgment. And then we go to the issue of amendment of judgment. Now, can the court amend its judgment after it has delivered its judgment? You understand? Now, there's something called functus officio. Functus officio. Once a judge has delivered his judgment, such a judge has become functus officio. He has been relieved of the responsibilities in relation to that judgment. You understand? He has been relieved of the responsibility. The only time he might have responsibility in relation to that particular case again is where maybe the Court of Appeal orders for the retrial. You understand? That is the only time that he might have another responsibility to handle that particular. That is even if the presiding chief judge, if the chief judge of the court assigns the case to his own specific high court again, because the chief judge can decide to assign it to another court. You know. So once a judge has delivered a judgment, he has become functus officio in that matter. He has been relieved of his responsibilities in that matter. Understand? So it is alien. It is alien for a judge to deliver a judgment and then amend that his judgment and deliver it again. It's alien. It's unheard of. It's unknown to law. It's improper. You understand? Such action by a judge is a nullity. You understand? Such an action is a nullity. By doing that, he has nullified that judgment. Understand? That was what happened in the case of Bakari against Apena. The court delivered the judgment, and then he amended the judgment. When we say amend the judgment, it could be finding of guilt, it could be sentence, it could be whatever. It could be maybe, he'll be like, the reason I gave for this judgment it's not proper. Let me give another reason, or let me remove that reason and substitute it with another one. You understand? So so in that case, is improper. But then there are exceptions. You understand? There are sometimes when amendment of the judgment may be allowed. So maybe he wants to correct clerical errors. Maybe there was typographical errors in the judgment. Too many typographical errors that they can't just leave it like that. And then maybe the errors in the judgment were due to accidental slips. You understand? Maybe at some point he wanted to write the claimant, the defendant, and he wrote the prosecution. You understand? And then maybe it's necessary to show the actual meaning and intention of the court. You understand? Now, this particular exception is very broad. You understand? It's very broad and it's controversial. It's very broad and controversial. But if the judge believes that his amendment will reflect the actual meaning and intention of the court, then and then he will have to go back and amend that judgment. And then it's also possible to substitute a punishment of caning on medical grounds. So we have, for instance, the defendant was convicted of an offense, and then a punishment of caning was imposed. Maybe he was given 15 strokes of cane, and then it is found out that the defendant is sick. You understand? He's sick. In that case, the court may have to amend the judgment and maybe impose another punishment. And then in the case of contempt in facie curiae, where the defendant has purged himself of the contempt. Understand? So contempt is one issue that one criminal issue with the court can just try you there, convict you there, and sentence you there ASAP. You understand? So maybe maybe you apologize and then you purge yourself of the contempt. The court can just amend his judgments and then not convict you for contempt. Maybe convict you for something else. And then to receive stay applications in the judgment. Once a judgment has been delivered, oftentimes that judgment automatically ought to be executed. Such a judgment could be executed. But it's possible that the person can appeal the judgment, and then in the course of appealing the judgment, they will usually apply for what we call stay of execution. You understand? The judgment should not be executed, pending the appeal. You have appealed against the judgment, and then the judgment should not be executed pending the determination of your appeal. I think, for instance, maybe the court imposed the punishment on a person that he should go and work in a community service. Community service is one of the punishment the court can impose. You should go and be working in farms for like series of hours every day. You understand? You can appeal against such a punishment imposed, by the court, and then you apply for stay of execution. So the judgment will be stayed. You will not go to the farm, pending when the court of appeal decides if you should go to the farm or not. So now, when the judge delivers his judgment, there are usually two types of findings, and the judge can make one, and that is either the finding of guilt or the finding of not guilty. When a person is found not guilty, the court will usually discharge and acquit the person. Understand? But then in the case of a guilty, if a person is found guilty, the court usually adjourn for sentence. The court usually adjourn for sentence hearing before passing his sentence. Understand? And then we have the issue of or the concept of conviction. Conviction. In the course of a criminal trial, after the judge has given his judgment, you understand, the court will usually convict. You understand? Now, conviction simply means to find him guilty of the crime charged. I hereby find you guilty of the offense of stealing. Understand? Conviction. That is what simply is called conviction. To find a person guilty of a crime, that means that person has been convicted. Understand? Conviction and sentencing does not mean the same thing. Understand? Conviction and sentencing does not mean the same thing. Conviction is simply finding the person guilty, and then sentencing is pronouncing the punishment on the defendant. Understand? I hereby sentence you to life imprisonment. That is what we call sentencing. Understand? And then the life imprisonment itself that was imposed by you is called the punishment. So these three things do not mean the same thing. So now, what is the effect of a failure to record a conviction before sentence? Now, what if the court goes ahead to sentence a person when it has not recorded guilty? Understand? It's more like a mistake. It's an oversight. What if the court now goes ahead to sentence a person without recording his conviction? That is the fact that he's guilty. Now, the law is that if the finding of guilt, can be gleaned, can be observed from the records, it will be considered a mere irregularity, and the appellate court can just remedy it. So if, for instance, at the Court of Appeal, from the record of evidence available to the Court of Appeal, that was transmitted to the trial court, that was transmitted to it by the trial court or from the trial court, it is clear that the defendant was guilty. Evidence adduced shows that yes, the case was proved beyond reasonable doubt against the defendant. Then it's just a mere irregularity. It was just an oversight. The Court of Appeal will say, oh, it was just an oversight that the court did not convict him first. You understand? But then if from the records before the Court of Appeal, the guilt of the person cannot be observed, cannot be seen, such a judgment might be rendered invalid and subject to retrial. You understand? And then also, if you fail to sentence a person, having convicted that person already, the Court of Appeal can also correct that. You understand? They can also correct that, provided the record before them shows that the person is guilty. And then we look at the next issue. Now, as a matter of a principle, the law says that conviction must relate to each count where several counts exist. So where, for instance, a defendant is charged with 4 counts of offenses, the court will have to convict. If, for instance, the prosecution has proved beyond reasonable doubt that he that he committed the 4 offenses, the court has to convict him specifically for those 4 offenses, respectively. You understand? So the court will find him guilty of committing the 4 offenses, respectively. You understand? For instance, I hereby find you guilty for the offense of stealing. I hereby find you guilty of the offense of assault. I hereby find you guilty for the offense of rape. You understand? So the court will have to convict him specifically. Specifically for each offense. The court cannot convict him in block. You understand? It's not possible to convict him in block, to say I hereby find you guilty for all offenses charged. Such is not proper. And the same principle also applies to sentencing. The court will have to also sentence him specifically for each offense for which he was convicted for. And then we ask ourselves, does the trial court have the power to take other offenses into consideration before sentence? So now, what if a person has been convicted of a particular offense before the trial court? Maybe the person is charged for the offense of stealing before the trial court, and then the person has been convicted. Now the court wants to sentence him. The person has been convicted. Now the court wants to sentence him. Is it possible for the trial court to take into consideration other offenses that the person has committed and that he's been tried for. You understand? Is it possible? Is it possible for the court to take such offenses into consideration before imposing its sentence? Now the answer is true. You understand? The answer is true. The court has powers to do so. The answer is true. You can see section 279 ACJ Lagos, 313 Agjan, 314 ACJ Kano. ACJ Kano. So, but there are, however, conditions. You understand? There are conditions that the court must fulfill before it can take into consideration other offenses committed by a person. Now, the defendant must have been found guilty of the instant offense charged. You understand? So, if the defendant is charged for the offense of stealing before the High Court of Lagos State, the High Court of Lagos State must have found him guilty of that offense of stealing. Before it will now talk about taking into consideration the offense of assault that the defendant is probably being charged for another place. And then the defendant must have admitted to those other offenses. So the defendant must have said, yes, I committed assault against Adeyemi around so time, and I'm being tried for the said assault at so court. You understand? And then the defendant must have agreed that the court should take same into consideration in his sentencing. So the defendant must also agree for the court to take those other offenses into consideration before his sentence. And then the defendant must have been charged for those other offenses. You understand? So the defendant must have been charged for those other offenses. You understand? So before the court can take those other offenses into consideration, he must have been charged. Maybe he has a pending case in another court in relation to those other offenses. You get? And then he must have been charged for those other offenses. And then the prosecutor of those other offenses must consent. You understand? And then the court must have jurisdiction to try those other offenses. So one thing I want you to understand, that it is possible that a defendant is being tried for like 3 offenses in 3 different courts. It's possible. Understand? Maybe that should not confuse you. It's possible that a defendant is standing trial in 3 different courts or in 2 different courts for different offenses. It's possible that someone is standing trial at the magistrate court for a particular offense. Let me say common assault, and then he's also standing trial at the High Court of Lagos State for, let me say, housebreaking. You understand? For housebreaking. You understand? He's also standing trial for maybe burglary or whatever. You get? So in trying him for, maybe the court is trying him for housebreaking. The High Court of Lagos State is trying him for housebreaking. He can decide that the offense of common assault against him at the magistrate court should be taken into consideration. You understand? So that they will just impose a cumulative sentence on him. You understand? But then it's relevant to know that there are certain precautions. If the court is taking such other offenses into consideration, there are certain precautions that the court must have to comply with. For instance, the court must not impose a sentence in excess of its jurisdiction. You understand? The court must not impose a sentence in excess of its jurisdiction. I said something like a cumulative sentencing. You understand? But that is not really in the sense I mean it. You understand? So, for instance, let's say for instance, the court has jurisdiction to impose a punishment sentence that is not higher than the court has jurisdiction to impose an imprisonment sentence that is not higher than 14 years. An example is a magistrate court in Lagos State cannot impose imprisonment punishment in excess of 14 years. So what if that magistrate court is taking into consideration an offense that is committed by the defendant in which is being tried for in another court, and then the magistrate also has jurisdiction to try that matter as well, and then the magistrate is now taking consideration of that offense, and the defendant has agreed and admitted, and the prosecutor of those other offenses has also agreed. You understand? So now, what if you look at, maybe say, for instance, the offense for which the person is tried for in the magistrate court is already punishable with, let me say, 10 years imprisonment, and then the offense for those other offenses that the magistrate court is taking into consideration, if you put them together, is punishable with 10 years imprisonment. You understand? So if you add them together, those other offenses punishable with 10 years imprisonment, and the one he's been tried for, the magistrate, punishable with 10 years imprisonment, does it mean that the magistrate can say, okay, since you have taken everything into consideration, let's just give you 17 years imprisonment? The magistrate cannot do that. The magistrate cannot, in the guise of cumulative sentencing, and they will now go in excess of his jurisdiction. He cannot do so. It's not possible. You understand? And then it's relevant to know that the court cannot impose a sentence higher than the the court cannot impose a sentence higher than the maximum sentence for the one convicted before the court. You understand? So even in taking other offenses into consideration, the court cannot impose more than the maximum sentence for the one in which the person is being convicted for or has been convicted for before that court. So now, in our criminal jurisprudence, for instance, sentencing has grades. There are gradations. There are grades to sentencing. An offense, for instance, may have 3 years imprisonment as the minimum punishment that can be imposed. You understand? We call that now minimum sentence. Now, that same offense can also have 40 years in prison as the maximum sentence that can be imposed. So in that case, the court has the latitude or the freedom to go from 3 years imprisonment to 40 years imprisonment, depending on the gravity, depending on how the person committed the offense. There's difference between burglary and aggravated burglary. You understand? So aggravated burglary, ordinarily, we carry more. Sorry, burglary is punishable with life imprisonment in Nigeria. Let me use housebreaking. Aggravated housebreaking, might ordinarily carry more sentencing than a normal housebreaking. I'm just trying to give you an example. You understand how the court can move from the minimum sentence to the maximum sentence. So now, if the court is taking into consideration, for instance, someone is being tried at the High Court of Lagos State, and then about 3 offenses he committed in the magistrate court is being taken into consideration. 3 offenses he committed that is being tried in the magistrate court is being taken into consideration. Now, the court cannot impose a punishment higher than the maximum sentence for that particular offense that he is being convicted for at the High Court of Lagos State. If the person is being convicted, then we go to the effect and consequences of taking other offenses into consideration. So now, once the court has taken other offenses into consideration, that convict cannot be tried again on those other offenses. That is the effect. You understand? So it's more like it raises this defense of bar plea. You understand? So the court cannot take those other offenses into consideration and sentence you. And then after serving everything tomorrow, somebody will say they want to try you again for that particular case that was pending before you in the magistrate court, because the High Court of Lagos State has taken that into consideration already. And then we now look at the principle of conviction for an offense not expressly charged. Now, is it possible that the person can be charged with the offense of armed robbery before the High Court of Lagos State, and then the High Court of Lagos State will convict him for another offense? Is it possible? Now, the general rule is no, it's not possible. You understand? That is the general rule. Why? Because ordinarily, a person must have to be convicted. Ordinarily, a person should be convicted for those offenses. Ordinarily, a person should be convicted for those offenses, for which he was expressly charged with and which was brought to his notice. If you remember your section 36 sub 6 paragraph A, that the defendant has rights. That the defendant has rights to know the offense. He has rights to have to have read to him in the language you understand, the offense against him. You understand? So that is the general rule. So once you have read the charge to the defendant, and then the offense against him is armed robbery, you cannot come tomorrow and convict him for another offense. That is the general rule. But then there are exceptions. There are instances where a defendant is charged with a particular offense, but then he's convicted for another. So now, it's possible for a defendant to be convicted for a lesser offense when he's charged with a grave offense. You understand? It's possible for a defendant to be charged with a lesser offense when he's charged with a grave one, but there are conditions that must be fulfilled. For instance, evidence adduced must support the conviction. Proof of the elements of the lesser offense must be embedded in the grave offense, and both offenses must be constituted in the same law. An example is an example is for instance an example is for instance a defendant is charged with the offense of armed robbery. I want to give you an example. A defendant is charged a defendant is charged with the offense of armed robbery, but then the prosecution could not prove the offense of armed robbery, and then he failed in proving the offense of armed robbery in the sense that he could not establish that the defendant was with an object or a weapon. He could not establish that the defendant was armed. In that case, if other evidence adduced is okay, the court can convict the defendant for robbery, because the difference between armed robbery and robbery is just being armed. You understand? But both of them involve violence or threats of violence. You understand? So if the prosecution failed to prove that the defendant was armed that night, but every other evidence adduced, sufficed, then the court can convict the defendant for robbery. You understand? So that is conviction for a lesser offense when a person is charged with a grave offense. But then this condition, evidence adduced must support conviction for the robbery. Proof of the elements of robbery must be embedded in the grave offense. The elements of robbery and armed robbery is the same. You understand? Violence or threat of violence must be there. The person must be the one who was seen at the crime scene. And then in the case of armed robbery, you will not add that the person was armed. But in robbery now, that element is no longer there. So you can see that the elements of robbery is inside of armed robbery. The only difference is just being armed. You understand? And then both offenses must be constituted in the same law. If you look at the what they call it, Robbery and Firearms Special Provisions Act, you know that they are under the same law. Subsection 1 talks about robbery, and then subsection 2 says if the person is armed, he will not be punished with this death penalty. So it's constituted under the same law. That is a perfect example. And then another instance when the court may convict a person for an offense not expressly charged is when the court convicts a person for attempt to commit offense when charged with the substantive offense. You understand? So it's possible that the person is charged with the offense of rape, but then the prosecution could not prove penetration. But then they would then convict the defendant for attempt to rape because he, from the evidence adduced, he really tried to rape the defendant. You understand? Sorry. The victim, you understand? The defendant really tried to rape the victim, but then he could not penetrate, but the strides, the attempt was obvious, you understand? So if a person is charged with the offense of rape, he can be convicted with attempt to rape if penetration could not be proved, but other evidence show that yes, he made efforts and attempt to rape the victim. And then it is also possible to convict the person for the substantive offense when the person was charged with attempting the substantive offense. In the Nigerian criminal jurisprudence, attempt itself is an offense. You understand? That is what we call inchoate offense or preliminary offense. So the fact that you attempt to murder a person, the fact that you attempt to rape a person is an offense, even if you did not succeed. You understand? So it's possible that ordinarily the prosecution took the defendant to court and charged him with the offense of attempting to commit an offense, to commit a particular offense. But then later on, it appears that the defendant really committed that offense. You understand? It's possible that the court can just convict him for that main offense and then abandon that of a charge of attempt. You understand? But then before the court can do this, the prosecution must, before judgment is delivered, amend the charge. You understand? But in this case now, before the court will convict the defendant in this case, the prosecution must have to amend the charge. You understand? The charge must be amended. And the procedure after amendment. The defendant will have to come and take his plea, on that amended charge and all those things. Those procedure we have to take course, you understand? And then that amended charge will be deemed to operate in the alternative. so that the defendant cannot be convicted for both offenses. You understand? And then it is also possible to convict a person for an offense not expressly charged, where that person has pleaded guilty to that offense not charged. Understand? Remember the position of law in ACGL Lagos, provided 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 the court accepts the plea, the court has jurisdiction, and the prosecution consents, the court can actually convict the person, when he pleads guilty to an offense not charged. And then remember the position of law in ACJA and ACJL Kano. It's not, in this case, it's not about the court accepting the plea or having jurisdiction. The court can go ahead to convict on that offense, but the prosecution must have to amend the charge. I think so, yeah. Must have to amend the charge to include that offense. But then now it's relevant to note, as a matter of exception to the exceptions above, that if a defendant is charged with a federal offense, on no account, he cannot in any circumstance be convicted under state law. You understand? He cannot in any circumstance be convicted under state law. So if, for instance, a defendant is charged with an offense which is purely federal in nature, he cannot be convicted for state law. You understand? So it is immaterial that state law is like the essence of this principle is just that, this is a federal offense, so you cannot be convicting a person under state law. In this case now, you cannot be saying, evidence are due support conviction. No. State law and federal law are not the same. You understand? Remember the powers of the AG. The federal relates to federal offense, and then state relates to state offense. And then we have what we call allocutus. Now, allocutus is an unsworn statement from a convicted person. When the person is making an allocutus, he is not referred to as a defendant because he has been convicted. Understand? So we refer to him as a convict. Understand? So allocutus is usually a plea of leniency. The person is pleading to the court. To be lenient, in whatever punishment the person is going to impose. You understand? The judge is going to impose. But it's relevant to note that allocutus does not absolve a defendant of the punishment. You understand? It does not absolve you of the punishment. It only mitigates. It can only mitigate. That is to lower. For instance, maybe the court wanted to impose a maximum punishment on you. After your allocutus, the court can decide to remove, let me say, maybe 4 years. Maybe the maximum punishment is 10 years in prison. The court can decide to remove 4 years and give you 6 years. You understand? It's possible. It has a mitigating effect. But then, there are instances where allocutus will not be of any effect at all. There are instances where allocutus will not be of any effect. If the offense is a capital offense, maybe you committed murder, your allocutus is nonsense. You must have to be killed. You understand? That is the law. You must have to be killed. And then failure to call on the convict to make an allocutus does not affect the validity of the sentence or trial. So even if the court did not call on the defendant to make his allocutus, it's just a mere irregularity. You understand? Because allocutus is not a fundamental right in law, and it's not also a defense. You understand? So whether the court called him to make an allocutus or not is immaterial. And then we go to sentencing. So we go to sentencing. And then we have two types of sentencing. We have custodial sentencing and we have non-custodial sentencing. I just skipped this point on preliminary point on sentencing. You can read that up. It's not really an issue. And then one of the punishment that the court can impose, I don't know why, during the lectures, the lecturers we are referring to this as sentencing, but in the recent it's supposed to be called punishment, because death penalty is not a sentence. Death penalty is a punishment, but it's fine anyway. So a person can actually be imposed with the death penalty. Now, death penalties are usually for capital offenses, and then it is legal. It is legal for the court to impose death penalty. You understand? Like it is permitted under our laws for the court to impose a death penalty. You can see the case of Honor Akalo against the states. I think in this case, the appellant appealed to the Supreme Court. I think so. Saying that the death penalty imposed upon him is a violation of his right to life, and the court was like, no. If you commit an offense which is punishable by death, you can be sentenced to death. You understand? Death penalty can be imposed on you. So how do we execute a death sentence that was passed on a person? How do we execute such a sentence? In the case of armed robbery, it is via firing squad. Any person who commits armed robbery is to be killed via firing squad. You understand? Attempted robbery is not the same as armed robbery. Attempted robbery is punishable with life imprisonment, not death. See Balogun against Ogun State. And then in any other form of killing, where a person kills in any other form or commits any other offense that is punishable by death, execution will be by hanging. Execution will be by hanging. But then if you look at the ACTA, Section 402 sub 1 allows for the use of lethal injection. Also, Section 2 sub 3, Kidnapping Prohibition Law of Lagos State, allows for hanging, lethal injection, or as a court may direct. And then it's relevant to note that not all set of persons can have the death penalty executed against them. You understand? Some persons are exempted from execution of the death penalty. For instance, if a woman is pregnant, you cannot execute a death penalty imposed on her. You understand? She's exempted. And then the relevant time here to consider is the time in which she's being convicted and not the time she committed the offense. So if, for instance, a woman was never pregnant when she committed the offense of murder, but then during the trial, she became pregnant, if the court imposes a death penalty on her, such death penalty cannot be executed. You understand? It cannot be executed because at the material time, the woman is pregnant. So you might look at the position of the law in different jurisdictions. Under the ACGL Lagos, they say where she's found guilty of a capital offense, she's sentenced to life imprisonment. You understand? And then they even said if she becomes pregnant after conviction, it will also be committed to life imprisonment. You understand? So if, for instance, after conviction, maybe during conviction she was not even pregnant, but after conviction she became pregnant, under the ACGL Lagos, she will have to be sentenced to life imprisonment. And then under the ACJA, if she commits a capital offense, she can be sentenced to death, but then they will not execute her until the baby is delivered and weaned. You understand? So they will have to give her some time to deliver her baby, breastfeed her baby to a certain period, and then before they then execute the death sentence on her. You understand? And then under the ACJ Kano, is similar to ACJA. She can still be, if she's convicted for a capital offense, a death sentence will be passed on her, and then but they will not execute it until 2 years. They will give her, in ACJ Kano specifies the number of years. Understand? They will have to give her 2 years where she has to deliver the baby and then breastfeed the baby for some time before they then execute the death sentence. Whereas under the Child Rights Act, now the Child Rights Act is more of it's more pro women, it's more pro life, So the child rights is looking at not just the interests of the woman as well, but the interests of the child. So under the Child Rights Act, they are saying such women should not be sentenced to death. The death penalty should not be executed on them. Even after 2 years, they should not impose the death. They should not execute the death sentence on them. Instead, they should maybe take them to special mother center, and then after 6 years, So the Child Rights Act is just supporting the right of women and children. But I wonder, if then they do all these things, what then is the punishment imposed on the woman for the life she took? And then if a woman is pregnant, the burden of proof is on her to provide convincing evidence, overwhelming evidence that she's in fact pregnant. And she can do this by way of medical evidence. And it is her duty to inform the court that she's pregnant. Otherwise, the court will not know she's pregnant. You understand? So if she's pregnant, she's the one to inform the court that she's pregnant. And then she must have to prove same medically by overwhelming evidence. And then young persons as well. Young persons are another set of people that enjoy some form of exemption. And then for young persons, that is children, minors, Now we look at the time in which he committed the offense and not the time of conviction. You understand? The time he committed the offense. If, for instance, a child was 14 years old when he committed the offense of murder, and then then maybe he's now being tried at the age of 24. The court cannot actually impose death penalty. It's not possible for the court to impose death penalty on him because at the time he committed the offense, he was 14. You understand? So children enjoy some form of exemption. So if you look at the ACJ Lagos, they say a young person up to 14 but less than 18 cannot be sentenced to death. He is to be detained at the governor's pleasure and may thereafter be released on license. And then under the ACJA, they say no sentence of death is to be pronounced, but he shall be sentenced to life imprisonment or to such other terms, And then under the ACJ Kano adopted the provisions of the Child Rights Act. You understand? They actually adopted the provisions of the Children and Young Persons Law. You understand? They say no sentence of death is to be pronounced and he's to be detained in a remand center at the pleasure of the governor. You understand? And then under the Child Rights Act, they say the best interest of the child is paramount and no death sentence is to be pronounced and no sentence of imprisonment is to be given. So if you look at the provisions of the Child Rights Act, the law is saying an alternative rehabilitative effort should be taken by the courts, and they should not impose a death penalty on the infant, and they should not also imprison him. So this is the form of pronouncing the death sentence. You have to memorize this. Under the ACJ Lagos, this is the format. The sentence of the court upon you is that you be hanged by the neck until you be dead, and may God have mercy on your soul. Similar to the format in ACJA, but just that ACJA adds lethal injection. And then under ACJ Kano, they say as the court may direct. You understand? So there is no specific format under the ACJ Kano. So as the court may direct. Then you might ask yourself, what is the effect of failure to comply with the above format? If the court does not comply with the above format in sentencing the defendant, does it have any effect? No, it does not have any effect. It's just a mere irregularity, that can be corrected by the court on appeal. And then we now look at the issue of prerogative of mercy. Death sentence is not the end of the road for a defendant. If a defendant has been imposed with a death penalty, you understand? Even if it's the Supreme Court, maybe he was imposed with the death penalty at the trial court, and then the Court of Appeal affirms it, and the Supreme Court also affirms it. It's not the end of the road, you understand? The defendant can apply for prerogative of mercy, you understand? That is for presidential pardon, you understand? It's possible. He can apply for presidential pardon using the appropriate this thing. If he's applying for prerogative of mercy, he doesn't apply at the Supreme Court, you understand? At the federal level, it is the Council of State that he applies to. At the state level, it is the Committee on Prerogative of Mercy. KK against the state. Somebody was applying for prerogative of mercy at the Supreme Court, so you can imagine. And the matter was struck out. And it's relevant to know that once a death sentence has been passed on a person, it cannot be executed until it has been confirmed by the governor or president in writing. You understand? So it's not just about the court imposing the death sentence. Same must have to be confirmed or signed by the governor or president before it can be executed. And then a notice of appeal filed. If, for instance, a death penalty was imposed on a person, if a person files a notice of appeal, that notice of appeal automatically acts as stay of execution of death sentence. Ordinarily, when a defendant is I give you an example with a community service. Somebody might be imposed with the penalty that he should go and serve the community, work in farms and all that, and then he will not appeal. It's not enough. He has to apply for what we call stay of execution. You understand? So that judgment against him will be stayed, will not be implemented, pending the determination, that is pending the decision of the court on appeal. You understand? But now for death sentence, if a person has been imposed with the death penalty or the death punishment, if he appeals, it automatically acts as a stay. You understand? So he must not go and file for stay of execution as well. Once he just appeals, it's an automatic stay of execution. That judgment cannot be executed pending until the appeal is determined. Another form of punishment that may be imposed on a person is imprisonment. You understand? Is imprisonment. It could be with or without labor, and where it is not stated, then it is deemed to be with hard labor. So immediately a person is sentenced to imprisonment. Upon the pronouncement, that imprisonment takes effect. You understand? That imprisonment takes effect, and then at the same time, the court may take into consideration the amount of time a person has spent in detention. Understand? So it's possible that the imprisonment sentence may take effect retrospectively. You might see a Yomi turn against the state. So if a person has stayed in prison for like 10 years, and then that is imprisonment sentence is 40 years, the court can say, okay, you have 30 years to serve. You understand? It's possible. And then sometimes imprisonment could run concurrently, or imprisonment could run consecutively. Now, if a person commits two offenses, and one is punishable with 5 years imprisonment and another one is punishable with 10 years imprisonment, if it's going to run concurrently, the person will just serve the highest, which is 10 years imprisonment, and he will come out. But if the imprisonment term is to run consecutively, it means that he's going to serve each of the imprisonment term for each offense he committed. So the total 15 years is going to serve it. You understand? Consecutively. After this one, you serve this one, just like that. And then there are some offenses that a person will commit, and then the law will say the person should either be punished with imprisonment or fine. It is possible. The court can say this offense is punishable with 2 years imprisonment or a fine of 300,000. Now, in this case, the court can decide to either imprison him or to impose a fine on him. But if the court says only imprisonment, then it means that such a person, if you commit such an offense, the court cannot impose a fine because the law says only imprisonment. And then look at the limitation on imposition of imprisonment sentence. There are limitations. A court cannot go in excess of its jurisdiction. Now, with respect to the law is that the court cannot impose imprisonment sentence higher than its jurisdiction. You understand? So, for example, magistrate court in Lagos is 14 years. They can't impose imprisonment sentence more than 14 years. Magistrate court under the ACJA is 4 years. And then for ACJ Kano, they can't impose imprisonment sentence 4 times higher than their jurisdiction. And then we also have punishment of fine, which is more like a pecuniary, that is a monetary, financial punishment on a person. And failure to pay fine leads to imprisonment. And then fine is usually to be determined by the courts, looking at the financial capacity of the person. Because, for instance, if the court imposes a harsh fine, the person can appeal against such a fine. And then if an imprisonment of fine is imposed on if the punishment of fine is imposed on a person and he refuses to pay, the court can commit him to prison. You understand? The court can actually commit him to prison. And then another punishment is the punishment of caning. Mostly, if you look at your past question, you see most times this principle, punishment of caning. The like is often coming out in the exam sometimes. Now, punishment of caning is applicable only to ACJ Kano. You understand? It's applicable only to ACJ Kano. And if you look at the circumstances for caning, the most important seconds, there are about 6 circumstances here, but the most important circumstances here that you have to take notice of is the fact that if a person has been sentenced to death, such person cannot additionally be caned. Understand? If a person has been sentenced to death, you cannot impose additionally the punishment of caning against that person. So you cannot flog a person and at the same time kill him. What's worse than killing? You understand? That's the most important circumstance or the most important principle on the punishment of caning that you must take notice of. And the sentence of caning cannot be administered by installment. For instance, now the court said they should cane you for like 15 strokes, and then you say today you want to take 5, and then tomorrow you want to take 5. And it's not done that way. You have to take it all. And then if someone wants to appeal against the sentence of caning, it has to be done within 15 days. And then the reception, there are certain people who cannot be caned. You understand? You can't pass a sentence of caning against them. Female offender, like girls, you don't flog them. Males, males who are sentenced to death, if the person is a man and he has been sentenced to death, you don't cane him. Male offender as well of 45 years and above. So if a man is 45 years and above, you don't cane him. And then a medically unfit person. If a person is medically unfit, you don't also cane him. And then there's something known as a hardy, or I think we also call it hardy lashing. It's also similar to caning, but it's mainly used against northern Muslims, and it applies mainly in offenses involving immorality, adultery by a man or woman, sexual offenses, drunkenness, defamation, and all that. There's no difference between hardy lashing and caning. It all boils down to flogging. You understand? They mean the same thing. Just that hardy lashing usually applies to some offenses like immorality, adultery by a man or woman, sexual offenses, drunkenness, and defamation. Understand? And then there are other forms of punishment that may be imposed on a person, like probation, forfeiture, community service, and nobody's going to disturb you with those one in exam. But one we have to look at is deportation. Deportation. Now, it is also possible. It's also a punishment. A person can actually a person can commit an offense, and then the court finds it legal to deport such a person. But such an offense is usually such punishment is usually imposed on non-Nigerians, that is, people that are not Nigerian citizens. So you cannot deport a Nigerian citizen. Take notice of that. It's not possible for you to deport a Nigerian citizen, no matter the offense he commits. The punishment of deportation cannot be imposed on a Nigerian citizen. You can see Sugar Bar against Federal Ministry of Internal Affairs. You understand? So the next topic we might look at is appeals. I may talk about it, I may not talk about it. Oftentimes in exam, they don't ask anything on appeals. Just know how to draft your notice of appeal. You understand? Know the omnibus ground and when it might be used. No bail pending appeal, but mostly just know how to draft your notice of appeal, your omnibus ground, appeal as of rights, appeal with leave, and then take notice of the fact that in criminal appeals, unlike civil appeals, there's no distinction as to the number of days you might appeal for interlocutory and final. In criminal litigation, is not in criminal matters, it is 90 days for the both of them, unlike civil where you have 3 months and 14 days, I think so. You understand? So that is what you need to mainly know in appeals. But it's not really, they don't really disturb students on appeals in exam.